will go on the record in the matter 25 CF 54, State of Wisconsin versus Zachary Chafee. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Chafee in person in custody with counsel Charlene Perrin. We're set here today in this matter for a plea hearing. The parties have reached an agreement. Ms. Perrin, can you please recite the agreement for the record?
Yes, the defendant will plead guilty to count 1 as amended to a class F felony. He will also plead guilty to count 4, maintaining a drug trafficking place. There will be a joint recommendation of 2 years, 6 months of initial incarceration. I'm sorry. There will be a joint recommendation of 2 years incarceration for count 1, 6 years extended supervision. On the second charge, there would be a joint recommendation of 1.5 years initial incarceration, 2 years extended supervision, concurrent to each other, eligible for ERP. We would be asking for no PSI for the court to go along with that joint recommendation. That is the agreement.
Thank you. Mr. Chafee, is that the agreement as you understand it?
Yes, ma'am.
Okay. And the basis for that agreement and how it was reached and in the public interest was stated on the record at the last hearing, I believe, due to the fact that I think it was only 15 grams after the lab, something around that nature. All right, so Mr. Chafee, I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, ma'am.
Did your attorney go over this document with you thoroughly?
Yes, ma'am.
Can I have you please pull the microphone closer to him? Thank you. Did she essentially go over it with you word for word?
Yes, ma'am.
And you understand everything completely?
Yes, ma'am.
If you didn't understand something, did you ask her to explain it until you did?
I understood it all.
Excellent. Is that your signature on the second page?
Yes, ma'am.
You are pleading guilty to count 1, an amended count of manufacturing, delivering a designer drug, and you're pleading guilty to 1 count of maintaining a drug trafficking house. Is that correct?
Yes, ma'am.
Formal motion to amend count 1 from a class C felony down to a class F felony.
So made.
All right, thank you. You're 37 years old. You have 12 plus years of schooling. You can read, write, you understand the English language. Is that all correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt as to both of these charges?
Yes, ma'am.
Did your attorney thoroughly go over with you the maximum possible penalties you face for both of these charges?
Yes, ma'am.
You are not receiving treatment for a mental illness or disorder, and you have not had any drugs, alcohol, or other medications in the last 24 hours, correct?
That is correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of that plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes, ma'am.
And do you understand them completely?
Yes, ma'am.
Now, do you understand that you will no longer have the right to a jury trial? You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
You understand that you're pleading guilty to a felony. As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Now, with regards to this matter, your attorney did attach jury instructions for manufacturing of a controlled substance. as well as keeping or maintaining a place used for manufacturing, keeping, or delivering a controlled substance, i.e. maintaining a drug trafficking place. Did she thoroughly go over those with you as well?
Yes, ma'am.
With regards to yours would be count 2, manufacturing, delivering designer drug. Do you understand that the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you did unlawfully and feloniously manufactured dimethyltryptamine in an amount greater than, or it's in an amount, is it less than 15 grams?
Apologize, I should have known that off the top of my head. So one's HM. So one. It's 3 grams or less.
3 grams or less. All right, so significant resolution. All right, so I'll go back over that right now. So with regards to this matter, the state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you unlawfully and feloniously manufactured dimethyltryptamine, DMT, in an amount less than 3 grams. And that would go from a class C felony, which you were charged, down to a class F felony. Do you understand what the state would have to prove?
Yes, ma'am.
And do you understand what it means to be a party to a crime? That means either you directly committed the crime yourself, you aided and abetted someone who was in the commission of the crime, or you conspired with one or more people to commit the crime, and affirmative steps were taken towards that commission of the crime. Do you understand what it means to be a party to a crime?
Yes, ma'am.
Do you understand the maximum possible penalty for this crime could be a fine of up to $25,000 or 12 and a half years of incarceration, or both? Do you understand that?
Yes, ma'am.
Do you also understand then with count 4, maintaining a drug trafficking place as a party to a crime? The state would have to prove on or around March 20th, 2025 in Burnett County, Wisconsin, as a party to a crime, you knowingly maintained a building which is used for manufacturing controlled substances in violation of Wisconsin law. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration, or both? Do you understand that?
Yes, ma'am.
Do you also understand that there is an agreement between the parties, and it has been recited on the record, and that both sides are requesting not to order a pre-sentence investigation report? Do you understand that?
Yes, ma'am.
Do you understand that I'm not bound to follow any agreement or any request not to order a PSI? Do you understand that?
Yes, ma'am.
I am free in my own discretion to sentence you to what could even be the maximum possible penalty if I thought it was warranted, and I have the authority and the right to order a pre-sentence investigation report. Do you understand that?
Yes, ma'am.
Now, with regards to this pre-sentence investigation report, do you understand what that is?
Yes, ma'am.
And it's going to have it's a document that's going to have a whole lot of information about you, about your history, both your personal, your family, your work, your school, your criminal history. It'll have a bunch of information, and it will also have a recommendation of sentencing from the Department of Corrections standpoint. Do you understand? I'm not bound to follow that recommendation.
Yes, ma'am.
Just like I'm not bound to follow any joint recommendation from both the state and the defense. Do you understand that?
Yes, ma'am.
Do you have any questions before I continue?
No, ma'am.
Now, did you go over that criminal complaint with your attorney?
Yes.
In particular, there is a section, it's called the probable cause section, where it basically says what happened and why you were charged with the crimes. Do you remember that?
Yes.
As it relates to both of the counts you're pleading guilty to, are those facts, for the most part, accurate?
Yes, ma'am.
Are you admitting here today that you in fact did manufacture a designer drug, which would be a dimethyltryptamine, DMT, as a party to a crime?
Yes, ma'am.
Are you admitting here today that you in fact did maintain a drug trafficking place as a party to a crime?
Yes, ma'am.
Are you pleading guilty to these 2 counts because you are guilty of these offenses?
Yes, ma'am.
Ms. Perrin, did you go over the facts alleged in the probable cause section of the criminal complaint with your client?
Yes,
Did you go over what the state would have to prove based upon those facts, as well as the maximum penalties that he may face?
yes,
Did you go over with him any potential defenses or a lack of defenses that you could see in this case?
yes,
May the court use the probable cause section of the criminal complaint to find a factual basis?
yes.
Has anyone made any threats or any promises to you for you to plead guilty to both of these charges? Other than a plea agreement?
Just a plea agreement, ma'am.
Okay, but no threats, no other promises?
No.
Now, so you're entering your pleas freely and voluntarily. That means you are telling me you fully understand what you're doing here today.
Yes, ma'am.
And you're doing so again voluntarily with full knowledge of what you're doing.
Yep.
All right. Has your attorney represented you competently?
Yes, ma'am.
Has she answered all of your questions?
Yes, ma'am.
Has she looked at this matter thoroughly?
Yes.
Has she discussed with you any potential defenses or a lack of defenses she sees in this case?
Yes, ma'am.
Has she discussed with you the discovery and the evidence that does exist in this case?
Yes, ma'am.
Did you discuss with her all of the facts that you know to exist about this case,
Yes, ma'am.
including any defenses you may believe you have?
Yes, ma'am.
Did she thoroughly discuss with you that it's your choice to go to a jury trial?
Yes, ma'am.
And so was this your choice to enter pleas here today?
Yes.
All right. So are you satisfied with her services?
Yes, ma'am.
Do you have any questions for the court or for your attorney before I proceed?
No, ma'am.
Ms. Perrin, do you believe that your client fully understands what he's doing here today by entering guilty pleas?
I do.
Do you believe his pleas are done freely, voluntarily, and knowingly and intelligently?
Yes,
Do you believe he fully understands the elements that the state would have to prove, along with the facts that would support each of the elements?
yes,
Do you believe he understands the maximum possible penalties that he faces,
yes,
and that it is the court's discretion in what it sentences?
yes,
Do you believe he's fully competent to enter his plea here today?
yes,
And you went over the strengths and the weaknesses of the case with your client.
I did.
Okay. Now, any questions, Mr. Chafee, before I take your plea?
No, ma'am.
Then as to count 2, manufacturing, delivering designer drugs less than 3 grams as a party to a crime, a class F felony, how do you wish to plead?
Guilty.
As to count 4, maintaining a drug trafficking place as a party to a crime, an I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of count 2 and count 4. The remaining counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court is going to order a pre-sentence investigation report. Long form. Agent does not need to appear, but should be readily available by telephone in case any questions arise. The court is hereby revoking bond. We need to set the matter for sentencing. I am ordering the pre-sentence investigation report. As I went over previously with you, I know nothing about you, Mr. Chafee. I don't know if you are a resident of Burnett County. I don't know your criminal history. I don't know your childhood. I don't know if there are things that you truly want me to know about you. That's why I'm ordering the PSI, and it is actually in your benefit for the court to do so. Let's schedule a sentencing. I could do May 8th, 9 a.m.
I can't do the morning on the 8th.
Okay. Do you know how long your arguments will be?
Mine will be short.
Okay, so you want to do 1 o'clock? Can you do 1 o'clock, Ms. Perrin?
I believe that I can. I just want to double check my CCAP calendar. Just to make sure that it is up to date, but I believe that will work.
Okay, just set it for an hour just in case.
Yes,
So-
that'll work.
May 8th at 1 o'clock, we will have the sentencing. We are adjourned.